Mic wasn't working, I just fixed it.
So before you have a seat, would you please join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Go ahead and be seated.
And that's what I was saying. I've never seen another trial start like that, ever.
Good to meet you. All right, so there's 3 cases on the court's docket today. 2018 CR 158, State of Ohio versus Rita Newcomb. 2018 CR 156, State of Ohio versus Angela Wagner. 2018 CR 154, State of Ohio versus Edward Jake Wagner. The cases are set for sentencing today. Mr. O'Brien, I'm sorry, he's not here. Ms. Knepp is here on behalf of, there he is. Mr. O'Brien, how are you?
Yes, Your Honor, I'm not appointed on that case. It's scheduled for sentencing.
Okay.
So I will not participate.
You're welcome to sit wherever you like. Appreciate your experience. Ms. Knepp is here on behalf of the state. I'll introduce the defense lawyers as the cases are called forward. I asked everybody to say the Pledge of Allegiance this morning as an acknowledgement that this is a government function. Sentencing in criminal cases is exactly that. There's a lot of different perspectives in the courtroom. There's a lot of different interests here. But the one common bond that we have in this function is that it's a government activity. So if you can understand my responsibility is to come at it from that perspective, you're all entitled to have your own viewpoint. But that was the start of it. Sentencings in most cases have a certain amount of emotion. The more egregious the case, the more difficult the facts, often the higher the emotions. In high-profile cases, there's expected public discussion. It's not unusual for people to later on go express their First Amendment opportunities and rights to communicate with each other. Often that means, did the judge get it right? Did he listen to the defendant's side or the victim's side or the state's side or whatever side they advocate for? And that's all appropriate for people to be able to have their perspective as a part of our First Amendment privilege. However, the right to public discourse really doesn't exist in this room outside the rules. And the rules are that decorum matters. So everybody's been well behaved, and I expect that to continue all the way through. as I explain the process to you, I'll expect you to follow the process. It's an open courtroom. The Ohio Open Courts Amendment to the Constitution allows
Not on mine.
through the
There we
internet
go.
or whatever access. That's all appropriate. I get that. But the right to public discourse has its limits, so the privilege of being here is only as good as you are. If somebody wants to express their First Amendment rights during the course of the proceeding, I'll shut that down really quickly, because in this setting with emotions on all sides of the case, there won't be any spirited debate. That can all happen out on the street, but it's not going to happen in the room. With regard to some preliminary matters, I want to call attention to the fact that the court staff has done a fine job pointing me in the right direction, getting me to the right places, helping with scheduling. So I guess I want to acknowledge the Pike County Common Pleas Court staff, and then carry that a step further is to acknowledge the Pike County Sheriff's Department and the STAR transport team with regards to logistics and public safety. So to the extent that the sheriff provides a lot of resources, the court wants to acknowledge that also. The process today will be as follows. There's some legal matters to take care of with regard to Angela's case and Jake's case. Best way to introduce them that way. So I'll take care of those preliminary matters after the sentencing involving Rita Newcomb, because that's a relatively straightforward case. But with regard to the legal matters, what I'll do then is this. First, have the state make a recommendation on all three cases, have the victim's statement on all three cases, sentence Ms. Newcomb after hearing from her lawyer and her. Then I'll switch to Angela Wagner's case, work on merger, then I'll work on Jake Wagner's case with regard to merger and sentencing. So we're going to do one state recommendation, we're going to do one victim statement that applies to all of them, and then we're going to individually sentence three people. There's a lawyer here on behalf of the victims, Ms. Gall or Golly?
Yes, Your Honor.
Thank you. Gall, G-A-L-L-E, but Gall. Thank you for being here. The only unresolved issue is whether or not the victim representative, who you identified as TR, would like that person's identity or their statement to be televised. They have the right to confidentiality, so I just need to know for the media how you want to do that.
Your Honor, there are actually going to be four victims that would like to address the court, and for the Constitution and their rights, so they do have the right to be heard at any public proceeding involving sentencing, especially. And I can get citations for that if you'd like, but TR is actually not going to speak. It's going to be for others. I believe Angie Canepa is reading two of those statements on behalf of the victims, and then there's another that would like to speak and
And this, I got about 30 seconds further than this, and this is when I knew I was pausing it and getting on here live with you guys. Because if you slowly watch his facial expressions, you can tell that he's either getting too much information that he doesn't want, or he doesn't want to hear it, but you'll see he starts to get very agitated.
So let's have an understanding. I just wanted to know first whether they wanted to be seen or not. So can you answer that for me?
they have no objection to being recorded.
Okay, thank you. Thank you. Now, the second question would be, why at the 12th hour you tell me that you have other victims and you entered appearances for people you haven't entered appearances on? I'm going to give you what you want. To a point. To a point. Because the obligation to come in and represent people doesn't mean to come in and change the script. So there's 10 minutes allocated to whatever four people are going to speak. I just need to have an identity for the record. If you want to use initials and give the court reporter their names, that'd be fine. But like you entering an appearance on behalf of somebody that doesn't want to speak really doesn't work for me. So don't answer that. Just understand that I'll give your four people 10 minutes and I want their identity and you want to give me initials, that's fine. Just write down their name so I have it for the record. Understand? Do you understand? Do you understand?
I need to make a clear record for purposes.
So you can make the record after we're done. Now, do you understand what I just said?
Yes, and I'm
Thank you. Okay, then sit down.
That's when I paused it and got off. He was very angry.
With regard to Ms. Newcomb's case, it's Mr. Gerlach, right?
Yes, that's correct.
Nice to meet you. So appreciate your representation, Mr. Gerlach. Any questions about the process? This recommendation from the state on all three cases, then the victim, then your statement, your defendant's statement, and then I'll sentence. You understand all that?
That's correct.
Does that work for you?
Yes, it works.
Okay, good enough. So Ms. Konepka, go ahead.
I just want to clarify, Your Honor, you want me to make a recommendation for Ms. Newcomb?
All three.
Okay. I would like to first place on the record, Your Honor, I did not file a written sentencing memorandum as to Ms. Newcomb. However, I am making the same objection to the timing of the sentencing that I made in both Angela and Jacob Wagner's case, specifically, Your Honor, as this court knows, based on Gilbert holding. The agreement at the time that these agreements were reached between the parties, there was also an agreement that the sentencing would be delayed until after the dispositions or resolutions of all of the remaining co-defendants in the case. At Ms. Newcomb's time in 2019.
Are you going to make a recommendation on sentencing?
I am, Your Honor, but
I got your objection. It's been in the record 5 times. I don't need to hear it again. It's overruled, so please make your
the
recommendation.
court is going to overrule me, but I need to make a record.
So, Mr. O'Brien, be ready to stand in, because there's no public debate today. The argument I'm hearing from your co-counsel has been beaten dead. It's been beaten dead. I asked her to make a sentencing recommendation. I asked her previously not to talk over me. The next thing that happens is she'll move to the back of the courtroom, and after that she'll be escorted out of the building, in which case you need to be ready to step in, because I'm not interested in old hash. She objected so many times, I have it in my sleep. I don't need it again. It's in the record. So I'm going to ask her again to make a sentencing recommendation on all 3 cases. If that doesn't work, then I'll take some disciplinary action. It's really easy to follow the rules until you don't have respect for the rules. So there's no...
I don't know what happened during this entire trial, but clearly the judge has had enough of her.
debate today. We're just going to do this. I'd like you to be ready to step in case it doesn't work for her. Understand?
Yes, Your Honor. Only thing I would say for the record is that I'm not privy to the previous plea agreements on Jay and Angela and Newcomb, so I need some time to review those before I would if required.
I understand. Thank you. They're all in writing. Thanks.
And at least I think that Ms. Vanessa should be ready to proceed.
I hope so.
Recommendations on
Yeah,
all 3 cases.
that's what I asked for. Now, recommendations.
Certainly, Your Honor. Regarding Ms. Newcomb, Your Honor, I'm deferring to the court on that. We did not have an agreed sentence in that case, and she has been very cooperative, and she did testify in George's case, and the case has been obviously pending for 5 years now, slightly more than 5 years now, slightly under 5 years, I guess, since her plea. And so I would defer to the court as to what Ms. Newcomb's sentence should be. As to Ms. Wagner, Angela Wagner, I'll proffer my objections after the court hearing so that I don't disturb the court any further on that. But I would simply ask the court to go along with the joint recommendation of 30 years. I know Mr. Craig has filed a sentencing memorandum in which he indicated that per a recent ruling, I believe December 9th, the court can only run 2 of the gun specifications consecutively. There are 6-year gun specs on multiple offenses, so of course the state would request that the court impose the 6-year gun specifications as the 2 counts. And then I don't really care how else the court gets to the 30 jointly recommended sentence. As to, I will note for the record that Ms. Wagner did appear and testify in her son's case, George Wagner's, in 2022. And the state believed, or believes still, that she testified truthfully in that case. So I would put that on the record as well. Regarding Edward Jacob Wagner, similarly, Your Honor, would respectfully request, and I obviously did forward sentencing memorandums, that basically says the same things, but that we would request that the court go along with the joint recommendation in this case, which is specifically, and I provided a chart to the court, just because I know at some point the court has to create a sentencing entry, and outlaying what the maximum sentence is in each of those. That was the joint recommendation, is that he receive maximum consecutive sentences. I think at the time that Judge Deering took the plea, obviously he also indicated he would be going along with the joint recommendations for what that's worth. And I believe during the colloquy with Mr. Wagner, he did ask him if he understood that he would probably, that he would not live outside of prison. And Mr. Wagner indicated that he understood that. The sentence that was jointly recommended is the same sentence that his brother, George Wagner, got, and then they are very similarly situated in that both of them went up on the hill that night and were responsible for the deaths of these 8 individuals, I should say, and on Fort Road. So again, Your Honor, I would respectfully request that the court impose the jointly recommended sentences. These were very carefully negotiated and constructed agreements. Both parties were fully represented, and these were the recommendations of all the parties involved.
Thank you very much. So, Ms. Gall, how do you want to introduce your first victim? Initials?
Yes, Your Honor.
Okay, so who's first?
Andrea Shoemaker, she does not.
Oh, okay. Thank you, Ms.
She's the
Shoemaker.
mother.
Go ahead. Thank you, Mr. Shoemaker. Just stand, if you would. Right there is fine. The court reporter is the most important person here. She needs to hear what happened, so go ahead. Thank you.
Andrea Shoemaker, I'm Hannah Hazel Gilby's mom. You three helped plan, carry out, and murder my grandson, Ruger, who was 6 months old, laying in the bed between his mom and dad, Frankie Roden, Hannah Hazel Gilby, let alone your grand.
All right, so that wasn't even written where I read it. So there was a baby, and it was over a custody issue. Maybe Hannah was the mom then, and the baby was who the family was wanting to get, but they ended up killing the baby.
Daughter's mother, how greedy of a grandmother are you? How greedy. You killed your granddaughter's mother. You're evil. You're evil. You are the spawn of Satan. And the Satan is Billy Wagner. You are the evilest mother to help plan, carry out, and take the lives of 3 other mothers. My daughter was only 20, and you want 30 years of your life behind bars? 30? She was 20! 20! She never even got to buy alcohol. She got 6 months of her life with her kid. 6 months. And Hannah Mae Roden, the love of your life, Jake Wagner. The love of your life. Your daughter's mother. She got 4 days. Kylie Roden got 4 days. Do you know what kind of questions I have to answer?
First it was bad people came in. Next, they seen your faces on the news. So guess what? I had to explain more. Because they're not kids, little kids no more. They're not 6 months old. They're not 4 days old. Ruger's soon to be 10. 10 years he's been without a daddy to teach him how to fish, to teach him how to hunt, to do all the man things. He has to depend on uncles, cousins. Because of you, Jake. Greedy Jake Wagner. You. I want you to suffer. This is what I want. And I've told all BCI. I want your mother to live and you boys to die as well as your dad. I want you to die so your mom feels the heartache of what it's like to bury a child. It's a heartache that never goes away. I hate you. You ruined my life. You ruined innocent children's lives. I hope you die. I pray every day you die. I pray your grandchildren and your children never want anything to do with you. And I hope they never do. I hope your daughter hates you with a passion and as much heart as I hate you, Jake Wagner. You shook my hand and acted as if you was my fucking friend. After you shot my daughter 5 times in the head. 5 times, man, while her son laid between them. And Hannah Mae, she's holding her little girl. And you shot her. How cold and evil. You are the spawn of Satan. I'll say it again. Spawns of Satan. You and your brother. And you, evilness, created them. And Miss Rita, I feel so sorry for you because I know you're ashamed to have such a daughter and grandsons that evil. Because you was the first to feel the guilt and say you were sorry, and it was your Christian duty to tell the truth. So I have not very many words for you. My heart breaks for you to have such an evil, controlled daughter and spawns of Satan.
Thank you, Mr. Maker. Who's next?
Actually, Your Honor, Ms. Canepa has 2 written statements that they requested she read, and then I do have one more live statement from Lisa Weisel.
Okay. Who's the first statement from Ms. Canepa?
It's Bobby Jolene, Your Honor, the individual who first discovered the victims in this case. This whole experience has been absolutely devastating. I just want to make it crystal clear that I hate you and I will never forgive you for what you've done. You're a coward. I hope the rest of your life is absolutely miserable. You don't deserve to be alive. It makes me sick that you're allowed to breathe the same air that I breathe. You have destroyed my life and the lives of so many others. There's a special place in hell for people like you. You want to act like you're a Christian, God-fearing man, and that cannot be further from the truth, for God hates people like you. You are the devil. All of this is because of you and your mother on a power trip, fueled by the need to control that poor child's life. And now your daughter has lost everyone. She no longer has her mother, Hannah Roden. You've taken everything from that child that you were supposed to protect and provide for. Your daughter will always remember you as a monster and a coward, nothing more, nothing less. All I really want to know is why. Why did they all have to die? Why did you think you had the right to take 8 lives? I'll never understand it all. It feels like a bad dream that I'll never wake from. Congratulations to you, Jake. You have made your daughter an orphan and put yourself in prison for the rest of your miserable existence.
That's the end of the first one.
That's the end of the first one, Your Honor. The next
And
one. I'm sorry.
as you well know, the court reports ability to keep up with words, not as quickly as we can talk.
I know you were limiting us on time, so.
Go ahead.
The next one is from Ruth Roden, who is the stepmother of Gary Roden. I would like you to know that you killed more than 8 people. Kenny, Gary's father, literally grieved himself to death over the murder of his son and the others in the family. Gary was a good-hearted person, and he could be the shirt off his back. He never missed his father's birthday or mine. He made it to every holiday. I truly feel that you did much more, so much more, these crimes continue to meet you. I ask for justice for Gary and the others in this family. Sorry.
Thank you very much. Last. What's your name, please?
I am Lisa Weigel. I am the niece of Chris and Kenneth and Dana.
Thank you.
I am going to be speaking on behalf of the Roden family today. My family feels very strongly that some people have lost sight of what has brought us to this courthouse over and over again, year after year. Let me quickly remind you of the magnitude, the severity of this tragedy. This monstrous crime is the largest massacre in Ohio. 8 people were brutally murdered, 2 young mothers and 1 young father. And I'm going to drop the baby's place I do. It is nearing the 9-year anniversary, and I assure you, no one wants justice more than our family. However, we do not agree with making hasty decisions to get it over with. We want all responsible parties to be shown no mercy, just like our family was shown no mercy. We can only pray that actions that take place in this courtroom today will not dismantle the justice that still has not been served. The Wagner family are master manipulators. It will tell of what the lies to fit their narrative. They are a true danger to society, and this crime is nothing to be taken lightly or play jeopardy with. And on behalf of me, and what I have to say, Jake, we are no longer a family. You've said that over and over. We will always be family. No, we will not. I will no longer ever think of you after today. When those doors close behind you, you will be an afterthought to the rest of our family.
Thank you, Ms. White. Okay, so Mr. Gerlach, you're first and your client, so go ahead. You can sit or stand wherever's comfortable.
Okay. I'm Attorney Franklin T. Gerlach, and I represent Rita Newcomb in this case. She has cooperated with the court and the prosecutor, and like I understand it, there's still another trial, and she is willing to do what she has done before. Now, looking at her, she's already been in the jail approximately 8 days, I'm not sure on the records. And for a year, she wore the ankle bracelet, and her movements and contacts were restricted. And she just recently had open heart surgery on which installed a new valve in her heart, and she's doing fairly well from that. She is on limited income. She gets $981 from Social Security, and we would offer to the court that perhaps the most appropriate thing would be a sentence that her service already be complete, and that there be no financial fine, because she really doesn't have the money to do that. Did you want to say something?
Thank you, Mr. Gerlach. Ms. Newcomb. Thank you very much.
And I'm sorry.
Stand up.
We just pray for all the trouble. I'm sorry.
Is that all? Okay, thank you.
Go ahead, have a seat.
And that would complete our presentation.
Thank you. So this offense is called obstructing official business. It's a second-degree misdemeanor. Maximum penalty is 90 days in jail and $750 fine. So that's the way the plea agreement was presented to the court. Those are the maximums defined by law. The other charges, whatever they were dismissed, so they're of no concern. with regard to the outcome, the probation department's been monitoring her behavior since 2018 and gives no negative reports. So that's a crystal ball in one respect, because the past often predicts the future, but it doesn't have to. So their recommendation informally, without a full report, is that she continue on supervision. So I'll set a 5-year term of adult probation supervision, 180 days jail, 173 suspended, 7 days credit. So no additional time now. You can, however, Ms. Newcomb, earn the additional 173 days if somehow you don't take this seriously and don't report or violate laws. So there's a long list of standard terms and conditions of supervision that the court's going to, wait, let's go with I'm talking first and you don't. This is how the problems develop, all right? So you've been on supervision, but it doesn't count, the past doesn't count toward the future, that's pre-trial. The past does help me indicate I don't expect to see you again because the probation department seems to think you're not a problem. But I'm going to put you on supervision for 5 years and tell you that there's 173 days suspended in case you can't comply moving forward. I'm going to order the $750 fine plus the court costs, and then your ability to pay over time will affect whether it's actually collected. Because if I don't impose it today, I can't impose it later. Understand? The terms and conditions of probation will primarily involve your compliance with the law, reporting requirements, and then any education or training programs they think are necessary for you to be a good citizen, which in your case may not be a lot, but that's generally the purposes of supervision, is to help people become law-abiding people if they aren't already. So 173 days at risk, there's a $750 fine, plus the court costs that have to be paid, subject to ability to pay. Understand?
Can I ask you a question?
Sure.
Do I have to go to jail?
You want to answer that or should I?
She didn't listen to a thing he said.
And I think no.
No, unless you act out.
Oh my goodness.
Okay.
173 days suspended.
Okay.
But it does demonstrate a good point. What I think I'm saying isn't what people are always hearing.
No, she just
But there
didn't
will be a
listen at
fine.
all.
And
Yeah.
if I'm bad, I'll go to jail. But if I can stay good, I don't have to. But I do pay the fine.
Yeah, subject to your ability to pay.
Okay.
Like, the point's not to put you in poverty. The point is to modify your behavior. If you have $30 left at the end of the month, then that should go toward the fine or the costs. At the end of the 5 years, if you can't pay it, you don't get incarcerated for being poor. It's forgiven at that point in time, but it is meant to be a punishment. Does that help you?
Yeah, I think I understand now.
Okay. Keep doing what you have been doing with regard to probation compliance.
But I still call in if I have to leave the state or something.
Or show up, whatever they say, you step and fetch it.
Okay.
Corrections or clarifications, Mr. Gerlach?
A clarification, in the entry, it says 90 days is the maximum.
I did say that wrong. It's 90 is the maximum. Yeah,
And you said 173.
I did. It's 83, not 90 is the maximum. I said 180.
Yeah,
I bumped it up a letter, so 83. Thank you very much. My sentencing entry is actually back there on the desk right now,
All right.
which doesn't help me here. Thank you for that.
Thank you, Your Honor.
So 97 credit, 83 suspended, $750 fine plus costs,
Yes, Your Honor.
5 years probation. Thank you for that correction. My apologies.
No problem.
Thank you. Ms. Canepa? Okay, you can check out right now if you would, Ms. Newcomb. That doesn't mean you have to leave the courtroom, just means I need that chair.
Oh, okay.
Thank you, Mr. Gerlach.
Thank you very much, Your Honor.
We'll switch to Angela's case next. And we'll need another chair. You can help us. I think we will. I don't have it.
I'm assuming this is the grandma of the grandchild.
You have co-counsel with you today, Mr. Ferentz? Are you
No,
by
I do
yourself?
Mark Hunt is not here today.
Oh,
I'm
my apologies. Okay. So this is State of Ohio versus Angela Wagner, case 156. Mr. Crapence is here on behalf of the defendant. Mr. Hunt's not appearing, so we don't need the extra chair. And you had an opportunity to hear the victim's statement and the state's recommendation, right, Mr. Ferentz? Crapence, I'm sorry.
You're fine. I have, Your Honor. Thank you.
Okay. And you heard it also, right, Mrs. Wagner? You heard everything that was said before, right? Okay. I want to circle back on one thing, Mr. Crapence. Was there any part of the plea hearing that you thought was in error or deficient or you wanted repeated?
No, at this time, nothing comes to mind.
Okay.
But
No, I wasn't here,
no,
but if there was an error, we can still fix it.
appreciate that.
Did you note anything that should be emphasized, Ms. Canepa? Any problems with the plea? Okay, thanks. So it's the defendant's opportunity to make a statement, so Mr. Crapence gets to go first, then Ms. Wagner, you get a chance, so go right ahead.
Your Honor, thank you. First, with respect to maybe some merger issues, I suggested in my sentencing memorandum that there are two sets of 2 counts each that we believe should be merged for purposes of sentencing. That was counts 16 and 18, as I recall, and I think 20 and 21, if I can read my writing here. And I won't repeat the arguments therein. I quoted the bill in particular with the specificity of what actually was charged, and it seems to me that they are of similar import such that they should be merged. I don't know that. I have not read a response to that, so I don't know the state's position on that. With regard to the sentence or the plea agreement and maybe the agreement on sentencing, Ms. Wagner is very cognizant of the fact that this court's not bound by anything that happened before this court took over this case. In fact, Judge Shearing also was not mandated to follow a jointly recommended sentence. Now, he did review it. He did say he would agree with it, but that in no way binds you. And my client is very aware that this court has the authority and the responsibility for deciding independently what the appropriate sentence is. So we do not walk in this morning expecting that this court will just rubber stamp the things that have happened before. But for the following reasons, I think that the court should accept the jointly recommended resolution in this case. As this court knows, these are horrible, heinous events. I appreciate the families being here and making the statements that they did. They have shown a lot of patience and I think and courage and repeatedly showing up for every hearing. I do appreciate that, and I know that their words do not fall on deaf ears. Your Honor, my client was involved with these actions. As far as her specific actions, she did not enter into any of these dwellings. She did not bring a gun personally. She did not pull a trigger. She did not directly cause the death of these folks. That said, she was aware of it. She took her own steps to try to assist in that plan. And that is something that she has taken responsibility for. In addition to taking responsibility, she has come into this court and she's testified against her son. And that was a task that was not very easy for her. It was important for her to do so, but it was also very important for the state. The state knew that the remaining cases after Jake had entered his plea were still not 100%, not an absolute win, because one person saying something sometimes without corroboration isn't enough to sway a jury to prove beyond a reasonable doubt. It's very important for them to have Ms. Wagner.
He's trying to put forward that she did good deeds by testifying against her son and filling in these little time gaps. She was also the mom and grandma of these people involved, and her being older and wiser and directing her son not to do something crazy. And no, she didn't do any of that. She knew about the plan. She helped them carry it out, even if she wasn't literally there firing a gun. She just let it all go and was going to let them do whatever. I think that the victim's mom says it right, that it's just evil.
Come in and testify and corroborate the testimony, the evidence, and the facts that Jake had testified to. Toward that end, after Jake had proffered, we never let Angela review the statement, the proffer, because we wanted to keep a clean wall between the two of them, such that she was not parroting back what somebody else had said. And I think it proved her value to the state as a witness. And it's because of those efforts that the state entered into this agreement, which I know the state probably didn't like, but felt it was necessary, and I think that they probably made the right call. Ms. Wagner has lived up to her end. She will continue to live up to her end of the deal, which again doesn't bind this court. I do want the court to know that she has provided me this morning with a list and some certifications of completion of some programs that she's taken while she's been incarcerated for a very lengthy time in Delaware County. And
Who cares?
I'm not going to read them all.
She still was an accomplice to murder.
Probably 40 to 50 different programs that she has completed. She has found something of a niche, and she's been in one place so long. She's been, entrusted to act as a trustee, but also has taken it upon herself to mentor young women who come in to jail, and then they come out, and they come back in, and she's told me many stories about the revolving door of women that she's met and been able to help. I believe that she, for the next more than almost 25 years of her life, will have a purpose. I know that she is the type of person who will listen, who will help to counsel, who will try to direct younger women into the right direction, a path that she hopes that they will take. She has done as much as she possibly can to improve herself, her situation, and to give back. She has written a statement at the appropriate time. I would ask the court to allow her to read that as well. All that to say, Your Honor, I believe that the jointly recommended sentence is appropriate. I know that in the plea agreement, we had agreed to a specific sentence for each of these counts. However, as my addendum to the sentencing memorandum indicated, I don't think that we can follow that because of how the Supreme Court has interpreted the law with regard to firearms investigations. I did include, it was yesterday at some point, a suggestion of how to arrive at the same, if the court is inclined to, and do so in compliance with what I believe would be the appropriate legal framework. Thank you.
Thank you. Ms. Canepa, do you agree that 18 merges into 16 and 19 merges into 20?
Into 20.
Unauthorized use of property, that's the way it was suggested by Mr. Craypence.
Yes, I would agree that there could be an argument as to 16 and 18, but not the 19 and 20, Your Honor.
Want to argue that further, Mr. Craypence?
No, so nothing past the motion. Thank you.
Okay, thanks.
He had an opportunity.
So I looked at the bill of particulars and read the indictment. I don't have all the discovery. When I read through the trial transcript, I can agree that 19 merges into 20 and 16 merges into 18 merges into 16. So I presume you would have the court's sentence on the higher level felonies, Ms. Canepa?
Yes, please.
So 16 is a felony 3 and 20 is a felony 4, so there'll be no sentences imposed on 18 and 19. They merge into 16 and 20. That being said, it's your turn, Ms. Wagner, for your statement.
Actually, you're here. I have to tell me if I'm close. There I go?
Yeah.
Oh, thank you.
I spent my whole life trying to be the opposite of everyone that I knew. Not too fluffy, not too wordless, not too strict, not too controlling, not divorced, not too ungrateful. The perfect daughter, wife, mother, grandmother, perfect person. Always striving for perfection, thinking that that was what was wanted of me. All of this had been stuck down so far that I didn't even know who that woman was. I didn't realize I was so weak and flawed and broken that it would lead me to make rash emotional decisions. That when such a tragic event would happen within my family, I just froze. I couldn't think. I'm not saying this for justification, Your Honor. This is why it shames me to say at that point in time, I didn't consider the consequences that those actions would cause, or the depth of pain that they would bring upon the Rosens or others. I know the pain must be unbearable, because separated from my family, the ones I love most in the world, brings me unbearable, suffocating pain too. And for this, I am so truly sorry. I can't undo what's happened. But the regret and the remorse that I feel is my daily reminder of who I once was and who I do not ever want to be again. Thankfully today, I'm not that woman. I've committed myself to change, to growth, spiritually, mentally, emotionally, to letting God be my guidance. Each day, I work on being a better me, rewiring my brokenness, living for a purpose so I can be filled with wisdom, knowing to slow down, to listen, and to ponder so I don't get carried away. With any emotional decisions again. I'm not looking for perfection anymore. Now my desires and goals are for continuous growth.
I think my mic was off for my
sharing
joke.
the compassion and
I'll just say that at the end.
to others that God shows me daily, and to remain this better me. God has opened my heart and my eyes. He has showed me what reality looks like. I've seen it in all the beautiful, unique women that I have met and been sharing housing units with. This world needs no more pain, so I give back any way I can, whether it is to show love, compassion, encouragement, a listening ear, a smile amidst their darkness, or just maybe by hearing my story, they will be enlightened of what real consequences made by emotional decisions looks like. My hopes and dreams are that I can make each day count for something good, to always move forward, not backward. Because all that I am today, I have to give that glory to God. It's His love, His mercy, and His grace that has changed me. Thank you.
Go ahead and have a seat. So, Mr. Crapence, let me start with you. Thank you. I don't think the public understands the stress on the lawyers for both sides of the case. I also don't think the public appreciates the fact that without defense lawyers, there wouldn't be a prosecution. Because in our adversarial system, as much love as the state might get, the defense lawyers seem to get the opposite. Yet you step into those shoes, and in this case, I've seen very capable lawyers working very difficult facts, often without any appreciation. So to the extent that you and Mr. Hunt did a fine job, you ought to at least be publicly acknowledged. So thank you very much for a long career.
Thank you, Your Honor.
The first part of the hearing, when the victims were speaking, was what I expected. A built-up, raw emotion of rancor and ill will, and all very understandable and unfortunate. If anything cathartic can come out of today, it might be of the fact that there's some closure, or maybe not forgiveness, not forgetting, but the fact that the process will have worked and people can move on. Whether you choose to accept that or not is yours, as any free person can, but maybe closure helps. There was a reference to this being the worst massacre in the state of Ohio. Well, let's go with something else. To call this the Pike County Massacre, frankly, is condescending to the rest of the good people of Pike County. It's tragic, it's heinous, It's unexcusable, but it's not an indictment of the entire county. That's social media typecasting. The worst massacre in Ohio might very well be 1792 at Canada-Hutton, when 96 Christian pacifists were killed by the Pennsylvania militia because they were Christian pacifists. But each generation has its own people who can prove the depths of depravity of human nature. And that's what this case did. It showed the boundless depravity of people who have no respect for others and their only self-interest in mind. And that's transgenerational. Since the dawn of man, this sort of depravity happens. So the raw emotion you communicated was expected is unfortunate, and I hope somehow you're able to get past it. Not forgetting, but getting above it. But good luck, because what I just asked isn't easy, as you well know. With regard to sentencing, however, the court's not bound by nor has any role in using emotion. The government's responsibility is not to use ill will. We don't have people being burned at the stake as in the medieval days. We don't have public shaming. We don't have a remedy that works. We have analytical guidelines.
So building them up, because I'm assuming he's not going to send her in for life?
The courts are supposed to follow in imposing sentence. It's not meant to be emotionally driven. So I wipe all the emotion and follow the sentencing factors. The first set of factors are whether the case is more serious or less serious. Clearly, it's a more serious offense for all the reasons stated in the statute. Whether recidivism is likely is a second set of factors. Well, there's a long sentence coming. And I'm supposed to predict the future, which I can't do. So recidivism prediction is virtually impossible. It's backward looking. So I'm just going to find that the risk factors for recidivism are balanced equally against the less likely, because I don't know what you're going to be as a person or who you'll be after your long prison sentence, Ms. Wagner. The fact that you completed 40 or 50 programs might bode well for you, and it might not. So I'm not going to try to predict anything with regard to the future. You need to understand that there's a mutually recommended sentence. If I impose the mutually recommended sentence, then any opportunity you might have to appeal the sentence is waived or given up. Generally, when a person enters a plea of guilty, they give up any rights to appeal the verdict of guilt. So presumably you don't have appeal rights as to your plea. If I impose the sentence today as recommended, then there's no appeal rights on that issue. The only thing that might be left, dare I say it, would be ineffective assistance of counsel, and I don't have any opinion on that. So if I impose a mutually recommended sentence, your appeal rights are waived as to the sentence. Do you understand that?
Yes, Your Honor.
And that's what's going to happen. I lined up the numbers differently than the lawyers recommended, but they come up to the mutually recommended 30 years. So for purposes of the record, with regards to count number 9, complicity to aggravated murder, I impose a 9-year prison sentence. On counts 10, 11, 12, and 13, I impose a 9-year prison sentence. That's an aggravated burglary. For unlawful possession of dangerous ordnance, count 14, the maximum 12 months in prison. For counts 15 and 17, tampering with evidence, 3 years in prison. Count 16, tampering with evidence, 3 years in prison. No sentence on forgery, no sentence on unauthorized use because they merge. On unlawful interception of the oral communication, 18 months in prison. And then for the obstructing justice in count 21, 12 months in prison. And then engaging in a pattern of corrupt activity, 9 years in prison. Mr. Crapence is right to remind me of the recent case of Beatty. I saw that come rolling out first week of December. Maybe that was in my entry 2 weeks ago with regard to having to follow the mandates. A lot of people might think judges have unlimited reign, if you will, to impose sentence, when in fact we have pages and pages and volumes of rules and case authority on how to impose a sentence. So the Beatty case tells me that there's a mandatory duty with regard to the firearm specifications to impose the maximum 6 years consecutively to each other. So there's a firearm silencer specification that has to be imposed on count 9 and count 22. So there's 6 years plus 6 years is 12. With regard to 9 more years for the aggravated burglary charges, those run concurrently with each other, consecutive to the firearm specification. So we're at 6 plus 6 plus 9. And then finally on the corrupt activity charge, count 22, there's a 9-year sentence, which is consecutive to the 9. So now it's 6 plus 6 plus 9 plus 9. Is my math right, Mr. Craigmans? 30 years. The other charges all run concurrently, so that felonies 3 and 4 don't add additional time. It's 30 years in prison as mutually recommended. You're entitled to 2,244 days credit over 6 years. 6 years and 6 weeks. So that comes off your sentence as a matter of law, because past time has to count. With regard to economic sanctions, there's no fine. Your inability to pay makes that impossible, not only in the past but in the future. There's a legal obligation to pay court costs, processing, booking, pay to state, medical expenses. So all those numbers should be added up and put on your bill. Your ability to pay depends on future economic circumstances, but it's a legal obligation to impose. When you're released, you have to be on supervision with the adult parole authority for at least 2 years up to 5 years. While on post-release control, you have to follow rules, regulations, restrictions on your freedom. If you fail to comply, you can be sent back to prison for up to 50% of the longest term, so that would be 50% of one of the 9s. So the 30 can turn into 34 and a half for additional violations after you're released at the end of 30 years. You have a legal obligation to register as a violent offender. There's a database. So at the time of your release, you have an obligation for at least 10 years to register as a violent offender. Tell the sheriff in the county where you reside where you live. If you fail to comply, that can be a parole violation, post-release control violation, or a separate felony 5 offense. And the legal duty can be extended if the state establishes just cause to extend it beyond 10 years, which doesn't start running until you're released from prison. Did I overlook anything, Ms. Kneppa? Mr. Crapens?
No, Your Honor. My client has signed an affidavit of agency from their clerk.
Thank you. Yes, sir. I'll hand this back to you. You can have the filing done. Further evidence, Ms. Wagner, of how thorough your lawyer is. See it? To the extent that I wasn't bound by the lawyers, I could have gone higher. I wasn't here when this started. The analysis is pretty true. The state needed you. And in fact, you came through with your part of the agreement. Does that matter? Well, morally, that's up to you. Legally, it's a big deal. In my journal entry, there's 2 cases cited that clearly explain the importance of cooperation, the benefits of mitigation. You helped the state make the case. Jake helped the state make his case. That wisdom, wherever it came from, was the difference between a much worse outcome that might very well have been appropriate. I understand you didn't go to the 4 scenes. Nobody seems to talk about the fact that you're the only person that could have stopped the whole thing with one phone call. You're standing there with cell phones that people want you to ping to make it look like you're home. All you had to do was call in. Stop the whole thing. The depravity was that you didn't see the moral need to shut it all down. I don't need an explanation, but clearly any decent human being could have done that little bit to save so much. So with the fact that you accepted responsibility and cooperated, I was willing to follow the agreement. You'll see the Anderson case and the Rahab case is cited in the decision. They go back to 2017 cases. The Supreme Court made it really clear twice in the same term the importance in the system of having people accept responsibility and cooperate. So for you, that's the only silver lining. That concludes that case. Ms. Wagner, they're going to walk out the side door. Moving on. Thank you, Mr. Craigman. It's my pleasure to meet you.
Thank you, my pleasure.
Have a good day.
So while they're transitioning, I'm gonna put it on mute so I can hear too. I wrote down that the mom of Hannah, who is obviously beyond devastated and upset, has to just be fuming because she brought up that she wants 30 years and my daughter was only 20, and that's what he gave her. So I'm sure she's devastated. I think that's why the judge was leaning in so much, trying to prepare everybody that you might not get the verdict you want, but it is what it is. I think this is Jake now.
Go ahead, have a seat. This is case 154, stated by Representative Jake Wagner. Mr. McVeigh's here on behalf of the defendant, Ms. Roberts. The new tire is also here. Were you able to hear the state's sentencing recommendations and your statements, Mr. McVeigh?
Yes, Your Honor.
Did you hear them also, Mr. Wagner? Did you hear the
Yes.
Did you have any issues or corrections you wished with regard to the plea proceeding, Mr. McVeigh?
No, Your Honor.
Think of anything on this case, Ms. Canepa?
No, Your Honor.
So what we'll do then is allow the defense attorneys to make their statements. You get a chance to make your statement. Choose to do so, Mr. Wagner. So that's how we'll proceed. You understand? I try to speak loudly enough, Mr. Wagner. I may not be doing that.
Oh, well.
Do you have a hearing? Do you have a hearing problem?
Yes.
Okay. I will try to speak louder and slower. But anytime you don't understand, do exactly what you did. Make it known.
Okay.
You can't miss this because of a hearing problem. Understand?
Yes, sir.
So thank you. Go ahead.
Thank you. We're going to do our best to make sure that he has full hearing and understanding and clarify anything that we may have some questions about. Your Honor, thank you for this time to speak on behalf of Mr. Wagner with regard to this sentence. I will keep my remarks relatively brief. I say relatively because the nature of this case calls for certain remarks to be made. But nonetheless, we have filed a sentencing memorandum on his behalf. This court is well aware of all the proceedings with this case, the joint recommendation of sentence, the plea agreement that had been entered into, as well as a defendant's agreement that was entered into and Mr. Wagner has complied with. up to this date and would continue to comply with. Again, my remarks will be brief, not because this is not a serious case. No one could, in their right mind, argue or anyone else that this case is not serious. And he spoke in terms of references to a massacre and that sort of thing. There are very few cases in the state of Ohio that would be of this severity. Certainly none that I have handled, although I've handled some multiple homicides involved. And but out of respect for the family, parties, and all involved here, given that this has been litigated, it's been tried in one instance at least over the last 6 years, there's very little that I can say that someone hasn't already heard. What I would indicate to this court is that we did enter into, Mr. Wagner and prior counsel entered into an agreed plea agreement and joint recommendation of sentence with the state of Ohio in this regard. That agreed joint recommendation of sentence was 8 consecutive sentences of life without parole for each of the aggravated murders involved herein. And it was also indicated that we would stipulate, agreed to waive and stipulate maximum consecutive sentences of both warranted, necessary, and appropriate in this case. I believe that probably would address the questions of merger. We know that Mr. Wagner knows that it's up to the court when it comes to sentencing. What I would indicate to the court is that he is fully aware that in entering the pleas that he did, he would be subject to a maximum possible sentence of 8 times life without parole, an additional 160 years if sentences were imposed to the maximum consecutive, and that 78 of the 160 additional years would be mandatory sentences. Again, the parties stipulated, or that we stipulated, Mr. Wagner stipulated to the necessity that consecutive sentence, maximum consecutive sentences were warranted, necessary, and appropriate in this case in order to effect the agreement of the state of Ohio. Again, Mr. Wagner understood what his maximum sentence could be. He understands and understood then that it would be up to the court as to what sentencing would be, but certainly he entered his pleas knowingly, intelligently, and voluntarily, knowing that he was subject to the maximum sentences as already addressed of 8 times life without parole plus an additional 160 years. He also understands with the joint recommendation of sentence, and he understood this at the time of entering his plea, that with the joint recommendation of sentence, he would not be able to appeal the sentence of the court if the joint recommendation of sentence wasn't imposed by the court. So I think he sits here before you fully knowing what those possible sentences are. He did at the time of entering his plea, and knowingly knows what the maximum would be. I believe I've addressed the issues of merger that the court wanted us to do, or asked the court, or asked us to provide additional information in that regards. Your Honor, I could stand here with myself and my colleagues in the Office of the Ohio Public Defender, having met with, and dealt with, and worked with Jay Wagner over the last 6+ years. There's many things that we could say. I could reference that my colleagues had told me, or things that I could tell you about the meetings and conversations I've had with Mr. Wagner. But I think, in all fairness and honesty to all parties involved here, that what probably speaks to Jake Wagner more than anything is the extent and the value of his cooperation in this matter. He referenced it in the sentencing of his mother, Angela Wagner, that without his information, perhaps convictions would not have been obtained, pleas would not have been entered, and the state wouldn't be in a position where they are today. So again, I think that speaks to Mr. Jake Wagner as much as anything I can say on his behalf here today. Your Honor, I believe that, at least by our calculations, we have 2,244 days of jail time credit. that calculation is correct. I believe that was from a date of arrest of November 13th of 2018. I believe it's close, if it's not completely accurate, Your Honor. And I support taking notice of that. I think the last thing that I would offer is that Mr. Wagner has signed an affidavit and we'll see if I may approach.
Yeah, please.
Some of these attorneys really like to talk.
Do you have a separate entry? Do you have a separate entry? Just sign them up.
Drive up to the board.
Your choice.
I don't have one with me.
I can do a margin note if you're satisfied with that.
I'd be satisfied with that, Your Honor. Thank you.
That's not that's it. There you are. Back to you.
Thank you, Your Honor.
Is that all you have, Mr. McVeigh?
Your Honor, I would just conclude by saying that, again, we did make a jointly recommended sentence. Mr. Wagner understands what his duties and responsibilities and promises have been in the plea agreement and the defense agreement. I believe that Mr. Wagner is a man of his word.
Thank you.
Thank you.
Ms. Roberts, care to add anything?
No, thank you, Your Honor.
With regard to merger, Mr. Neck, same argument, same discussion?
Yes, Your Honor.
Okay.
I suppose the court will reach the same conclusion.
Yeah, the same conclusion. So I think the merger is the same in this case as it was in Angela's. Academic as it might be, it's nonetheless essential to get it right. Your turn, Mr. Wagner. Anything you want to say?
Actually, Your Honor, I have a lot I want to say. But it's all right.
Just pull the mic closer if you would, and try to keep your voice projected.
You can hear me now?
Yes.
No, I have a lot I want to say, but if it's okay with you, instead of looking at you, I would like to look at the victims' families because they are who I really want to
You're
speak to.
entitled to do that.
You don't do that?
You can.
Oh, I can?
You're entitled to do that.
Oh, I can, okay.
Yeah, so whatever's comfortable. You can stand if you want, you can face them, you can face me. Just make sure no disrespect happens.
No disrespect, no.
Go ahead.
The family's probably unhappy about this.
So, each and every one of you, well, not all of you, obviously, but I've had friendship or relationships with a lot of you, many of you. And I know full well that the weight of my crimes is what I've done to you and your family. There's no amount of apology I can give today, no amount of explanation, no thing I can do to help you with the pain you have, loss, anger, hate. Nothing can save that. But I'm not going to tell you, oh, this, and that. I'm going to tell you about me. Because, yeah, I used to be a manipulator. Ms. Gilly affirmed that, and I truly was. But after I committed this crime, I was still guilty. Ms. Gilly, I'm going to look at you because I feel you have the most hate. And this is for you. So whenever I committed those crimes, it was probably 2 or 3 weeks later, I was weighted down with the guilt I did. And I said the most sincere prayer to that day I ever said to that day. And I asked God. I didn't like what I did. Didn't like how I was living. Didn't like how the possibility of my daughter or even my nephew would grow up to be. And I asked God. I said, put me and my family back on the straight and narrow path by any means necessary. Any. And I can tell you today, I am not sorry I got caught. I'm sorry for what I've done. But I am glad I got caught. I 100% believe that it was Jesus who made me get caught to answer my prayer so he could become exactly who he's supposed to be to each of us. Lord and Savior. Because, silly, now I don't show much emotion. It's not in me. Quiet hour tonight, you've seen God, I do. I won't show much here. I'm kind of breaking up a little bit, but that's just me. I can tell you from my own experience, hate will not heal your heart. I'm not asking you to forgive me. I don't. But I ask you, if you are a woman of at least some kind of faith, you should really read the Bible, because hate won't do it. Hate will only condemn.
What is with all of these people going after the victims in this and trying to preach to them, saying that hate isn't in the Bible and you need to read it to let go? And Sarah Boone talking about forgiveness and that it's holy and good for you to forgive. So that's what you should be doing because she forgave everyone. Why do they feel like this is the right time or place or right people to be talking to about this? It is beyond me.
Yourself. But I want you to know, what I want to tell all of you is how I was, and how I believed, and how I truly thought I was going to die and go to heaven prior to being arrested. And how I learned in my own time, alone with Jesus, just him and his word. I set aside every human teaching I was ever taught, even John 3:16. I read the word for myself. John 3:16 don't save you. The Bible don't save you. Only a relationship with Jesus Christ will save you. And he did not promise one place in his word. I don't know how many of you have ever read the Bible. He's never promised he would save you from hell. He promised that he came here to save you from sin, to unleash you from the captivity of sin. We're all weak. We all fall short of the glory of God. I knew that, and I was one of those people who believed, okay, sure, I'm a sinner, I'll sin every day. It's not like, why should I try? I ask for forgiveness when I eat, go to sleep, and I'll be good. I wasn't good. That's not what Jesus preaches. Jesus says specifically, you come to me with all your burdens, all your sorrows, all of your pain, and you surrender, and he will heal you. You know, some of you might know the verse where it says you must become like a little child, or you by no means enter the kingdom of God. You must repent, or you by no means enter the kingdom of God. Repentance is what I thought prior to actually just sitting down and reading the Bible myself. It's not asking for forgiveness. That comes from repentance. Repentance is to choose to look at what you've done, hate it, and forsake it. Forsake sin. Nobody can say that they are a God-fearing Christian, born again, and think sin is nothing. At least little sins. Lying. Lying is just as much an abomination as any other thing. I've committed murder. I've committed every single sin that the Bible lists.
He has not said he's sorry to them. Not that that would help, but he is not offering anything in this subject line right now. It's just crazy that he thinks that this is okay to be doing instead of maybe trying a little bit harder to give them closure on the situation.
Blasphemy, denying Christ, like Peter did. No, he never actually said it, but I have been in silence, and I heard someone else say it. And it's just as much sin. To me, I'm going to tell you exactly how God changed me. And I know it's taking a little bit extra time, but I feel the judge will.
And there goes her family. That is exactly what I was waiting for. I cannot believe that this is what he's using his time to do, and they shouldn't stick around. They don't need to hear this.
It took me about 2 months after I was arrested. And I read that Bible twice, cover to cover. And I did not like what I found. Not the fact that it doesn't give salvation. The fact that I realized I did not have it. I realized I did not have repentance and never did. Yeah, I believe it was superficial. My superficial faith had no power to change, no power to save, no power to have godly works in my life. Not one bit. But I was deceived. And every time I read it prior to that, I kept deceiving myself. Well, John 3:16, I'm good. No. You gotta read John through 14, 13, all the way to 21. He tells Nicodemus about repentance. He doesn't say a word, he tells it. Men don't want to men don't want to repent if they don't want to come out of darkness. Because their deeds will be brought into the light and be reproved. That's repentance. You know what we ask Jesus?
I truly don't know how her mom is still sitting in there.
Do save us, change us, because we're sinners. He does not call us into a life of sin and just save us from that. No, he calls us into a relationship so that he can transform our life, so we will be adequate ambassadors of Christ on earth in his love and his forgiveness. Whenever, seeing this feelings back, but when all of you guys can probably have the same feeling that she does. When she said that, no, it wasn't crying on my eyes. My heart was breaking for her, just as it breaks for all of you. Because you may be in the darkness that I was in. The hate is the darkness. And I can tell you, not in spite, but I'm not miserable. I don't live in misery. I've experienced your loss, I've experienced your pain. This is my mom mentioned. Because I believe that God done this to me, so he could help me have the compassion and empathy to feel what you guys have felt. Shoot, he's taken my daughter from me, my nephew, those two more than precious people in my life. And he's done that, I believe, so that I would know how he feels about all his lost children. And that's what I do. I don't need to tell you about how good I am or this and that or what the things I do, because it's not important. I tell you this only because I care for each of you, each of your pain, each of your loss and your sorrow, because kind of like what they mentioned before, the judge mentioned, it's not about forgetting. Past is in the past. Strive for the future. But I can tell you this, I don't forget what I've done prior to my born-again moment. And I would describe it to you, but there's really no sense in doing it here. But whenever I was born again,
It makes no sense to do this here. Can't believe he's still going.
I stopped forgetting. I didn't try to forget. I told my testimony to everybody I come across. I told it to them so that they may know that sin's not okay. Crime is not okay. It does hurt more than just us. It hurts everyone around us. Everyone we've known, we don't even realize we're hurting. And there's a consequence to that. And I'm fully aware of my plea. I'm fully aware of the mercy that I've already received. And I am completely willing and ready to pay my consequence for my crimes here. But I want you to know that I have joy and peace and love in my life every day. It doesn't mean I don't suffer the loneliness or pain every now and then. It comes. And when it comes strongly. But I trust in God, because he gives me comfort every time it does. And what he does for me, he can do for you. And I'm not trying to make myself look big and think big shot on the news and all that stuff. Because I know everybody and everybody. But many people are going to criticize what I say today. And don't get me wrong. Now you can see I cannot write this down. Because for the past 3.5 years I have been thinking about what to say. How I can help you. Not justify myself, fix it, or anything for myself. Whatever the right word is. But how I can help you. Each and every one of you. Even my daughter, wherever she may be. Everyone else who I've hurt. I want you to know the love and forgiveness that Christ has for you. So that he can bring good, as he promises, out of this terrible situation to help those who still have the opportunity to help. And I'm going to tell you one example of that.
Mr. Wagner, start wrapping it up, will you?
Thank God.
That's 3 minutes.
Wrap it up.
One thing, and I want to tell you, Sheriff, not all the details. If I came in contact with another inmate, this is after my plea. And he told me, because I told him, I'm confidential, I'm like, not necessarily how a Catholic priest does it, but what you confess to me, I'm not going to tell no one else. And he told me about he was going through a similar situation I was. How he was planning as soon as he got out. He was going to go kill his baby.
Stop.
Say what?
Even the fire department wants him to be done.
Okay.
Okay. Go ahead, 2 minutes.
Well, I was able to spend time with him in a lot. And I was able to share with him what my consequences and the pain I've caused to so many people. And I was able to lead him to making a choice for Jesus and not to commit to doing what he said he was going to do. And you know, there's so many people out there who have gone through so many things that you've gone through, sometimes even worse than what you've gone through. And I've read of so many testimonies how they have brought God glory through the evil that has happened, both on my side, the offender, and even on the offended side, showing his forgiveness. And I tell you, forgiveness is a powerful thing. It melts so much the hardest hearts you'll ever see. And I do that every day with my testimony. My fellow mates, my brothers. I love them.
I realized
I
my
shout
mic was out. I was saying that it's crazy that he is bringing up the fact of forgiveness and the bad things he's done, but then saying that the defendant did bad things too. You are literally at their trial for their murder, and that's what you're going to do?
To them. And I don't care how much I get persecuted for being called a snitch, for being called everything under the sun. And it's odd because they don't criticize me for what I did, for the crime. They criticize me for taking the plea. They criticize me for standing up here and doing this, what I did for my brother. All of that.
Mr. Wagner, wrap it up, will you please?
My last sentence. I'm sorry. I just want you to know, Jesus has a cost. Obedience, repentance, and total commitment. And when you do that, as I've done, if you've all done it, I don't know, you will transform your life. I hope you all have been touched by that, and at least somewhat plant a seed that your hearts may be healed, at least somewhat. And I do pray for you all. That's all I got to say.
I hope you've been touched by that. Oh my gosh.
Nothing further, nothing to mention on that. Thank you very much.
So, Mr. Wagner, that allocution, that statement, further demonstrates the role the court does not serve.
I know.
Everything you just said is perfectly appropriate. It's been heard many times before, as has the victim. But to the extent that there's a religious overtone, I don't factor in religious values. It's the same standard. The legal prescriptions, the laws of the government that I impose. I heard remorse. I heard your understanding and your explanation for it. But to the extent that you might, or somebody might have taken that as preaching, that's fine, except it has no meaning to me.
But did you hear remorse? I mean, I heard him say the words of that he wishes he didn't do that and he is sorry for it, kind of, but he doesn't act really remorseful.
Except for remorse. If it was more than that, Mr. McVeigh helped me understand, but it just demonstrates that the same ill will and rancor that came from the victims, and understandably, is now your faith experience on your side, neither of which is the role of the judge, the duty of the law. So it highlights what goes on in courtrooms on a regular basis.
Your Honor, what I might add to that, perhaps by way of further explanation, is that I believe from my conversations and conversations with my colleagues with Mr. Wagner, that the statement that he made there was, he wanted to speak to the victim's family, and rightfully so. But I don't believe it was in any way intended to sway the opinion of this court when it comes to sentencing.
We said the same thing different ways.
We did.
I can't accept that.
We did.
For benefit of the record, a lot of the victims in the gallery walked out along the way as they're allowed to. So they don't have to hear what he chooses to say. It's how it works.
Yes, Your Honor.
In fact, this day is more intense than many, but it's all too familiar on the criminal court dockets.
Yes, Your Honor.
With regard to sentencing, Mr. Wagner, the court has the same analysis. Severity factors, well, obviously, clearly, there's more serious factors. There are no less serious factors. With regard to whether you're likely to be a repeat offender or not, I'm not going to have a crystal ball to project where you are after a long prison sentence, so I'll just find that the recidivism factors balance out. It's unpredictable, but I did the analysis and thought about it. With regard to the penalties to impose, count 1, aggravated murder, life in prison. Count 2, aggravated murder, life in prison. Count 3, aggravated murder, life in prison. Count 4, aggravated murder, life in prison. Count 5, aggravated murder, life in prison. Count 6, aggravated murder, life in prison. Count 7, aggravated murder, life in prison. Count 8, aggravated murder, life in prison. Count 9, conspiracy to commit aggravated murder, maximum 11 years out of Department of Rehabilitation and Correction. Counts 10, 11, 12, 13, aggravated burglary, maximum terms of 11 years in prison. Count 14, possession of a dangerous ordinance, 3 years in prison. Counts 15 and 17, tampering with evidence, 3 years in prison. Counts 16 is tampering with evidence, 3 years in prison. Count 18 merges, so there's no sentence on 18. Count 19 merges, so there's no sentence on 19. Count 20, unlawful interception, 18 months in prison. Count 21, obstructing justice, 12 months in prison. Count 22, engaging in a pattern of corrupt activity, the maximum 11 years in prison. And then count 23, unlawful sexual conduct with a minor, a 4th degree felony because of more than 4 years of age difference. In that case, 18 months in prison, the maximum sentence. With regard to firearm specifications, the court's duty-bound under the recent Beatty case to impose mandatory 6 years on the first firearm spec taken from count 1 and 6 years on the firearm specification found in count 2. You're entitled to 2,244 days of jail time credit up through including today. You're required to register as a violent offender. You also have sex offender registration requirements. The sex offender registration requirements apply upon any release from prison, which would be for a period of 25 years, registering at least every 6 months with the sheriff in the county where you reside. If you change your address, take into employment, then you have to change your registration anytime you change your variable. The violent offender database, as you heard earlier, is a 10-year registration which can be extended. And if you fail to comply with the sex offender registration or the violent offender registration, that can be a violation of any terms of release or a separate felony at the time. The Chief Justice appoints retired assigned judges to work on cases where there's conflicts or problems. And I take that very seriously. It's a privilege after retirement to be granted the opportunity to come back and continue to help my colleagues. That's why I get out of bed every day. There's a need, there's a problem, maybe a skill to apply to resolve the need and the problem. That's how I got here. We talked about this with your dad months ago. I got 2 problems when I walked into this case. I'm going to explain the 2 problems. The first problem was a recommendation on your case that was the same as it was on your brother's, life without parole, which is what he got, right? How did he get there? He went to trial. He had 10 weeks of trial, and he had thousands of dollars and dozens of witnesses and emotional energy and staff energy, people energy, resources energy to get him to his conviction. Yet the recommendation here is the same, giving you no credit for all the cooperation that you gave as Mr. McKinney said, if you don't have corroboration of a cooperative witness, you may not have any case. So I have to resolve the first problem is how is it that I'm supposed to treat you the same when in fact you didn't act the same? That's the first problem. The second problem is how do I resolve the good deal that your mom got? 30 years is a really...
I think my mic was off for that. I'm just going to summarize really quick. I said that I think the judge cares way too much about them and them confessing and then giving details to help out the state. And I don't see why he cares so much because he maybe helped, but he still killed 8 people. I don't see why he feels like he needs to reward him somehow.
Long time. That's a really good deal for the level of the conduct, especially since she could have stopped the whole thing dead in its tracks before it ever happened. And I don't let her off the hook because she didn't go to the scene. I put her equally responsible because the eyes of the law put her equally responsible. So my second problem is how do I resolve what looks to me like some sort of gender violence? And here's how I resolve it. I give you the opportunity of parole after 20 years on your prison sentence. So you do 6 on the gun spec, you do 6 on the gun spec, you do life on all the other counts, everything concurrent, with the opportunity of parole at 20 years. So 32 years out, you get your chance because you cooperated, because you did something to acknowledge the responsibility for the crime. That's not a deal, but that's as close as I can come to solving the problem that's handed to me by these ancient plea agreements. If everybody wants the last judge's sentencing deal, they should have sentenced him under the last judge. Everybody knew Judge Deering was gone right after the last trial. But nobody rushed it in to get it, and when I show up, I solve the problems the way I'm supposed to. So you get your chance to talk to the parole board 32 years from now. And then they do their job, whatever it might be. So I'm not going to sign off on a deal where you get the same for cooperating as your brother does for going to trial. There's the explanation. Court costs, processing, booking, paid state medical expenses, have to pay as a legal obligation. There's no victim restitution because they have civil remedies available. So you can go ahead and be excused. We're going to register you under both those registries. And we're going to take a break. So we're going to go off the record. Thank you to the lawyers.
Oh my gosh. I cannot believe that. I cannot believe the judge just said he can be up for parole after 32 years. All because he ended up giving details because he took a plea agreement. I am shocked. I don't know if I've ever seen another judge make this kind of call. 8 people were murdered, and yet he has the chance of walking free in 32 years. It's just nuts. All right, let me see if I can skip ahead. People, I'm not going to get over this. That's ridiculous.
Oh, Mark, you got money. Yes, I do.
Okay, go ahead and have seats. Right, 2018 CR 157, State of Iowa versus George Wagner III. Set for motion hearing today. Mr. Collins, Mr. Hayes, Ms. Anstead, Ms. Stevens are here for defense. Mr. O'Brien, Ms. Canepa here for the state. I think there's two matters for the record versus defendant's motion from last December, renewing a motion regarding other acts testimony. So it'd be like the scope of admissibility. And then the court's willingness to hear re-argument with regard to the death penalty specifications. So we'll try to knock those two things out of the ballpark here. I don't know, Mr. Collins, Mr. Hayes, you want to talk about the motion? I think it's pretty much oral argument, but maybe it's hearing, but evidence.
I thank you very much. I please the court on behalf of our client, Your Honor. We received the government's response to 12:36 last night. I didn't look at it until this morning around 8:30. So with the court's indulgence, we kind of split this up. We're going to let Ms. Stevens make the argument, the oral argument. But I guess would you? I'm sorry.
I didn't see any of it yet, so you're still ahead of me.
Okay.
Go ahead.
Would you like a copy?
They're probably just going to get in the way, so we're good. It might have been filed, I just don't get things because I don't have a
I
staff.
thought I emailed it to you at the same time.
You emailed me
to them.
at 12:36 last night, it's in my inbox. I left to get here at 6 this morning, no problems, I just don't live on the web. Yeah, like I'm good with all like not finding fault with anybody. I'm just saying you're ahead of me. I read the motions, I looked at the transcripts from the past.
Okay.
I'm already trying to formulate a plan of attack.
May I approach?
Yeah, please do.
There's no writing on there.
Appreciate it, thanks.
So I guess with the court's help, Your Honor, we didn't know, Ms. Canepa, the government broke it up into chunks and argued 7 or 8 other acts.
It has handwriting on it.
You didn't see what Jake got, Beverly? I'm assuming you mean Jake and not this guy because he just got here. Jake got he got life in prison, but after 30 years, he can be up for parole. And the only reason why he got the parole is because he took a plea deal and gave some details to the different policemen. That's the only reason why. But there's 8 people that he murdered, and he gets to parole? That makes no sense. I fundamentally disagree with this judge. And they didn't say exactly who this is now, but I'm assuming it's either Jake's dad or his uncle.
I'd like to do that.
Sorry about that.
Thank you.
You wouldn't be able to read my the government, Your Honor, took each concept in different chunks, and there's maybe 7 to 10 other acts in each of the chunks, so we can either argue in chunks, Your Honor, or in big areas, or if you'd like us to go through every single other act, we're prepared to do that as well, that they listed from their February of 2021. So Ms. Stevens can address that, or we can talk about each one, whatever the court would entertain.
I should just start locally, chunks, if you will.
Thank you very much, Your Honor. May I proceed?
You sure can.
May it please the court. Firstly, Your Honor, the state of Ohio's response relies on a Supreme Court case decided in 2020, State v. Hartman. And we would submit, Your Honor, that the Hartman case is absolutely instructional for this case because it held that that other act evidence was inadmissible. Evidence of the same character that we submit that the state is seeking to introduce with this other act evidence. In addressing, Your Honor, the state's first chunk of an argument, it uses identity. And it uses identity as an umbrella argument, stating that identity is an issue in this case.
However, Your Honor, we would submit that just because identity is an issue in this case, it's not a license for a prosecutor to introduce any type of allegation going back in perpetuity against the defendant. And that's what we have here. The state of Ohio has evidence in the record contrary to modus operandi or the identity of the other act evidence in which it seeks to introduce. In the Hartman case, Your Honor, the Supreme Court held that similar act evidence is only relevant. Thank you, Your Honor. I apologize. In the Hartman case, the Supreme Court held that similar act evidence is relevant only if the jury can reasonably conclude that the act occurred and the defendant was the actor. In almost every other act that was listed in 2021, our client, Your Honor, Billy Wagner, was not the actor of the other act evidence that the state of Ohio seeks to introduce. And the state has evidence, Your Honor, evidence in the record that Billy was not there. Billy was not present for this conversation. Billy did not threaten. That Billy lived with his mother at the time that the state is seeking to introduce these other acts. Identity, Your Honor, as the court is aware, is a permissible purpose under 404B when there is a modus operandi, when there's evidence, indicia of modus operandi. We would submit, Your Honor, that none of the information, none of the other act evidence that the state has provided conforms with, shows that there's a modus operandi here. As the court's aware, modus operandi means literally a method of working. Evidence, Your Honor, that the defendant has committed uncharged crimes with the same peculiar modus tends to identify the defendant as a perpetrator of a crime, a fingerprint, or a signature, if you will. The court may have heard it as a strikingly similar doctrine. An example of such, Your Honor, of a modus operandi type for which another act can be admitted into a trial would be something like a fingerprint or a signature. A serial killer shaving the head of his or her victims after every killing. Taking trophies from every type of murder. That is the modus operandi, that is the exception that the Supreme Court of Ohio contemplates, but the state argues that identity here is absolutely an issue and that therefore modus operandi is an issue. We would submit, Your Honor, that modus operandi is not an issue. The utility of modus operandi, Your Honor, comes from its connection with the current crime through shared characteristics that make the conduct unique to the perpetrator. Here, Your Honor, the accused perpetrator is Billy Wagner. There is no fingerprint like of someone who is not our client hacking a Facebook. And these are just examples, Your Honor, of the other act evidence that the state is trying to introduce for Mr. Wagner's trial. There's nothing modus operandi about any of the evidence that the state seeks to admit. As far as common scheme evidence, Your Honor, the Hartman case is also instructive on how this court should rule. Other acts that are admissible for a plan or common scheme must be so inextricably linked, and the other acts must be of the nature that they are carried out in furtherance of the same overall plan. Evidence of a common plan design refers to a larger criminal scheme, of which the crime charged is only a portion. That's what the Hartman case held. The Bill of Particulars, Your Honor, informs we as the defense that the charges we have to defend against, specifically the engaging in corrupt activity charge, stems from January 1st of 2016 until November of 2018. The engaging in a pattern, that conduct that is specifically mentioned in the Bill of Particulars.
We're trying to decide in advance what's relevant evidence. But the reality of it is you don't make that decision until you get to the courtroom and have the full context. So when they
had issues earlier with this. There we go.
That's what we're trying to sort out. It has a lot to do with the nature of the charges. It has a lot to do with the scope of the indictment, but it's going to be advisory. It does help because, frankly, we've got to make sure we're efficient when we try the case. There's no sense bringing in a witness from someplace that's going to take the stand and find out in 30 seconds everything they want to say is not coming in. So I'm pretty much a harper on make the railroad.
This issue is with the courtroom camera. It happened earlier
And the scope of
in the trial.
the trial.
Mayor,
Go ahead.
may it please the court, with regards to, would you want a written response to the government's motion from us? Would that help, or?
It's still them. Let me see if they got it.
I'm probably not going to give you a chance to argue with you. I'm just going to do what I got to do to get there. Thank you for helping me. Seriously, we're making progress. Everything that happens in the room isn't everything that happens.
I believe it's still their issue.
I know the courts, defense attorneys are allowed to talk to the court ex parte about fees for experts or whatever. I don't know how much they got done. You know, I mean, this case was indicted in 2018. I don't know how much they got done.
For you to decide, because you're the one telling me we're not going to need mitigation. So either you intend to keep the death penalty all the way through, or you intend to remove the death penalty mid-trial. And now if you're saying it's definitely not negotiable, I want to know if it's not negotiable.
Oh, no, I'm not saying.
I really hope this isn't on my end. The court camera was losing audio and video earlier, so I assume it's still them.
If he testifies. If he doesn't, then I would not. So that's not I mean, that's always been the case. That's never been different.
Talk to all those people out there that don't read social media, but like every time I get more information about the done deal, dismissal, withdrawal, it helps me understand the validity of the statements that we're not going to be doing this. Like every time you come in and tell me more about ethical problems, ineffective assistant counsel, and now here's the terms of the agreement, I better understand how you were all too optimistic in your assurances that we weren't going to be there. So I'm not going to, I get your problem. I'm not going to have that answer, because I would consider that a strategy. So thanks, you have a different time.
Yes.
Go.
I would like to amend the bill of particulars. The count 6, 7, 8, and 13 should say Scioto County. It's in the transcript that they were provided, and they provided the transcript 2023 sometime. But when, you know, the court asked for the bill of particulars, and I was looking through it myself for the other act stuff, it's possible I've done that already, but I don't know that I have done that. So I would move to amend the bill of particulars.
How do you want to handle that? This is year 9, right?
Sorry?
This is year 9. We're coming up on the 9th anniversary, right?
Charged 18.
Yeah, the facts happened in 16. Okay. I'm just like being a little bit snarky at the moment because I can see it from your face, so why don't you just like have at it? The indictment's in 2018. I understand the bill of
What I was
particulars.
going to say is that the lead-in language to the indictment says that within the body of Pike County, or some manner enumerated in 290112 of the Ohio Revised Code, where the proper venue is placed in the county of Ohio on their oaths in the name and by the authority suit. So
How do you want to handle the request for amendment? You want it in writing and then you get a response in writing?
Yes, sir.
Yeah, like I get where we are. Didn't see that one coming. But that's why I asked for the bill of particulars. Like, I'm to the point now where I can drill deeper into all the stuff that you're years ahead of me on, if in fact you're ahead. So she's going to file a written motion to amend the bill of particulars, and you want how much time? Okay. And then how much time behind it did you want for your very capable staff?
7 to 10 days.
Okay, we'll have a good, solid record of what we're asking for. Anything else you want? Mr. Bryan looks like he's got one.
No, I was asking Ms. Knapp if similar to the court later. There was anything, so I have nothing further. Thank you.
All right, anything else?
Oh, thank you very much.
All right, thanks again to the court staff. Go ahead and stand adjournment. Oh, no, we won't. Let's talk about our next scheduling. Phone call, do that. I'm going to do it right now. Go off the record. Let's get our calendars and phones and things like that.
Okay. Well, wow. You have to let me know what you thought of all of that madness. Even so, we weren't following along during the entire trial. Today was definitely interesting to learn about the case. And now I really want to go and look up this specific court and read through some of the things that they had appeared there. I'm just still shocked that he got 8 life sentences for killing 8 people, and yet the judge gave him parole. I just think that's crazy. I thought it would just only take away the death penalty, but the parole option, I just really don't understand. And I want to see if they actually are doing that at this court more than other courts, because all the people we see who are in this type of situation, it's in jail for life, no parole. So not going to let go of that. I'm very annoyed with that. We probably will see if when he comes back for his sentencing, we might try to check it out, just because I did think this was interesting. I'm surprised I didn't hear about this trial, but probably because all the other ones were just more nation known. I don't know. But as always, thank you for watching. I am planning on trying to get on later today. I don't have a timeline yet, though. It would probably somewhere between 9 and 10 probably. So if you're